Nike filed and lost a dispute over a domain name that consisted solely of the word Nike. And the case is a good lesson for trademark owners trying to decide whether to file a complaint under the UDRP, or Uniform Domain Name Dispute Resolution Policy. Hi, it's Doug Isenberg, and in this video, I'm going to explain what happened in the UDRP case for the domain name nike.dev and how the owner of one of the best-known trademarks in the world, a brand that Forbes values at more than $39 billion, failed to convince a UDRP panelist that the disputed domain name was registered in bad faith. The case was filed at WIPO, the World Intellectual Property Organization, and decided in February 2021. As I said, it involved the domain name nike.dev, which uses one of the so-called new GTLDs, or top-level domains. .dev was delegated back in 2014 and is part of a small portfolio of TLDs operated by Google, which promotes it as a secure domain for developers and technology. But it is an unrestricted TLD, meaning that registrations are available to anyone on a first-come, first-served basis. According to the UDRP decision, the registrant of nike.dev created it in February 2019, and it resolved to what was described as a largely undeveloped website. This is a screenshot of the website using the domain name shortly after the UDRP decision was published, which shows a photo of a statue of Nike, the Greek mythological goddess of speed, strength, and victory. The site also contains a disclaimer that says that it is in no way associated with the Nike brand. But the UDRP decision said the disclaimer was added a few days after the domain name complaint was filed. Now, Nike, the company, is of course the famous shoe and apparel business that was founded by Phil Knight in 1964. The company's history is profiled in this inspiring and intriguing book that Knight wrote in 2016, Shoe Dog. Now, Nike has filed close to 100 UDRP complaints through the years and has won almost all of them. Its first decision came back in 2000, the first full year of the UDRP, for the domain name niketown.com. And its most recent victory was for nikegiveaway.info, a domain name that was being used by a cyber squatter to promote a sweepstakes, supposedly offering $1,000 Nike gift cards, but it was actually a website that contained malware. Now, in the nike.dev case, Nike argued that there is no believable or realistic reason for the registration or use of the disputed domain name other than to take advantage of Nike's rights. And it also cited the so-called passive holding doctrine that allows a trademark owner to establish bad faith even in the absence of an active website associated with the disputed domain name. I previously explained this passive holding doctrine in another UDRP case study video in which I discussed the landmark case of Telstra versus Nuclear Marshmallows. In any event, the registrant of nike.dev argued that the domain name was not registered in bad faith under the UDRP, instead that it was intended to honor the Greek goddess and was to be used for personal projects, including apparently in connection with a VPN, or a virtual private network service. In his decision, the UDRP panelist had no difficulty finding that the domain name was identical to the Nike trademark, but ultimately he found that Nike had not proven the bad faith element. While the panelist said that it was a close case, he also noted that the complaint and response provided what he called a fairly limited factual record, and that Nike had not met its burden of proof. Specifically, here's what the panelists wrote about the burden of proof. Despite the obvious fame of complainant's Nike trademark, the panel can find no basis in the record upon which to conclude, on a balance of probabilities, that respondent registered or has used the domain name in bad faith. The burden of proof rests with complainant, and in these circumstances, the sheer strength of its Nike trademark has not carried the day. This is what sometimes happens in UDRP cases because the process was designed to be quick and efficient, which sometimes means that the parties don't have a full opportunity to discover what might be important facts, either before or after filing a UDRP complaint. And as a result, in this case, Here's how the panelist handled the issue. He wrote, "Respondent lays out a simple explanation for his motivation vis-a-vis the domain name. It is not abundantly supported, and some aspects of respondent's account are somewhat dubious. Even so, respondent presents a fairly cogent explanation and asserts quite rightly that in appropriate circumstances, a domain name may be put to personal use, even if it resembles a well-known trademark." In other words, not every famous trademark, even one as famous as Nike, is automatically entitled to protection under the UDRP, especially where a domain name registrant makes a plausible argument that it was using or intended to use the domain name in a manner that does not directly impact the trademark owner. Now, whether the registrant of nike.dev truly intended the domain name to be a tribute to the Greek goddess, or whether this was just a pretext for some other activity was, at the end of the day, apparently not something that the UDRP panelist in this case felt he could determine. And in cases like this, because the burden of proof is always on the trademark owner, the decision ultimately was in favor of the domain name registrant. Now, I wouldn't read too much into this decision. I certainly don't think it opens the doors in any way for cyber squatters to register famous trademarks as domain names with impunity. But where a trademark also has another meaning, and where, as the panelist in this case said, the domain name registrant can offer a fairly cogent explanation for its activity, then the UDRP might not provide a remedy. In my practice, that's always something I try to anticipate prior to filing a complaint to make sure that the complaint is worth filing in the first place, and if so, to include all potential factual and legal arguments to help ensure success. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.